Can a divorce affect your firearm rights? The short answer is yes, but let me explain. First of all, just because someone is divorced does not mean they lose their firearm rights. Let's get into this. What happens during a divorce is some of these judges are filing what they call temporary orders. And these temporary orders include language on what the parties are going to do while the divorce is going on. Now, what's happening is these judges are including language that tracks more like a protective order, okay? So a protective order is something you go seek if there is domestic violence or something of that nature, and you want a protective order against someone, they stay away from you, and there's further penalty. If you're under that protective order, under federal law, you are prohibited from possessing a firearm. Now, these temporary orders, these judges are including that language, okay? So different title, same language. So what happens is when someone's going through this divorce proceeding, they receive one of those orders. The federal law says it doesn't matter what the title of the document is, it matters what the language in the document is. So even though it may be titled something else, if that language tracks that protective order language, then you are prohibited under federal law from possessing or owning a firearm. So if you're going through something like this, or you know someone that is, they need to make sure and ask their attorney how to interpret that and how it applies to them as they're going through that proceeding.